Court is now in session with your host, Peter Briggs.
Welcome to the Lawyers and Lay People podcast, a conversation-based podcast featuring interviews with some of Georgia's top lawyers, where we, in an easy-to-understand way, answer the questions that are on the minds of you, the layperson. In this podcast, we talk to specialists in a particular field of law to hear directly from them as to what clients typically ask them and what they should be asking. I'm your host, Peter Briggs. I graduated law school in 2006 from Georgia State University here in Atlanta, and I've been practicing as a lawyer for almost 17 years. I'm a personal injury and bankruptcy attorney as well as a registered mediator. Our guest today is Randy Williams. Randy serves as president and managing partner of Williams Law Group of Georgia. Their website is thewlgfirm.com. He specializes in real estate law, criminal defense, and litigation. Randy brings business and executive ingenuity to the firm's leadership. He obtained his Doctor of Law from Emory University, where he prosecuted misdemeanor and felony crimes under the Fulton County Solicitor General and DeKalb County District Attorney. All right, well, I want to thank our guest, Randy Williams, for joining us today on the podcast. Randy, I know your specialty is real estate law. Why don't you tell our listeners what is it you like about practicing real estate law and how long you've been doing it?
So real estate law is interesting to me because the issues in it can be so diverse, from landlord tenant issues, from issues related to closings, foreclosures. And it's just something that, everyone needs a place to live and to reside. So the issues that we have here have always been of interest to me. I have been involved in real estate for over 20 years. Not only am I a practicing attorney, but I also have owned and operated a real estate brokerage firm. So just the issue, I'm an investor. So all of that just has always been something that has piqued my interest. And I've been doing it for quite a long time.
All right. So you mentioned landlord tenant. You, I understand, have represented both landlords and tenants in these disputes. Is that correct?
That is correct. Landlords and tenants, normally because of, what our fee structure is, I'm normally, if I'm representing a tenant, it's likely a commercial tenant. But there have been occasions where just residential tenants have needed our services and saw fit to invest the expense in hiring an attorney on their side as well.
Okay, so let's then start off from the residential tenant perspective. Let's just say now the residential tenant, they're struggling to pay rent. What should, just from your experience, they be doing? Is there anything to be doing when they're a little bit behind on the rent as far as proactively reaching out to the landlord, or is it the kind of thing they just get the eviction notice and then deal with it at that time?
No, so you do want to, especially for Metro Atlanta. Metro Atlanta is a very can be a very expensive market, and there are a lot of people looking for lease space here in this market. As such, you do want to not damage yourself from being able to get another rental because you don't handle the one you're in properly. So if you find that you are experiencing a temporary issue with being able to afford the property that you are now leasing, I strongly suggest that you get in contact with the landlord. I would strongly suggest that the tenant sees if the landlord is willing to make some concessions, is willing to potentially go into a payment plan, or participate in some of the rental assistance programs that are available in almost all of the counties in Metro Atlanta. That way, at least the tenant and the landlord are working as partners, and it doesn't become unnecessarily combative between the two, because the tenant does want to try to preserve their tenant rental history, so that way the next property they're not paying excessive fees or being denied even the right to rent their next home. So if you find yourself that you're behind and it's a temporary issue, I would suggest talking with the landlord. If you find yourself behind and it's a more permanent issue where you just have you find that you're not going to be able to afford a property, then it's probably better that you work out an exit strategy with the landlord in a way that the landlord may, not want to file eviction on you and further harm your credit or your rental history.
Okay, so I know you represent landlords in these kind of situations. So first off, just at the beginning stage, what should they be doing or can they really do up front that you recommend before signing the lease with the tenant as far as, I don't know, credit report checks or background checks? Is that something that your firm sometimes handles?
Yeah, so landlords do have this obligation, right? Because you are going to put in basically a stranger into a property that, owners have paid, hundreds of thousands of dollars for. So you do want to make sure that you understand who's going into that property. My recommendation is that while the technology of today has made things very easy to be able to do things on electronically, from signing the leases to making payments to accepting the original deposit, I do think that some landlords fail to do that very basic human part, which is to actually meet with the person that's going into their property, to actually have a face-to-face encounter so that you will know who they are. You can see them. You can get some vibes from them. Besides the regular checking their employment history, checking their rental history, and all of the credit background check things that people, as a basic obligation, you should do, but also get to meet them, because all too often I end up with cases where the landlord couldn't tell me who all was living in their property. They know they signed a lease with someone. They assumed that the person they signed the lease with was the actual person that was living in their house, and they come to find out that it wasn't. Maybe somebody, used someone else's name to rent a property out, and they just never saw fit to actually inquire by having that basic meeting. So landlords definitely want to make sure that you know who's going into your properties. Do you know where they work? Do you know who they bank with? Because if something were to go wrong, you need to know who you can collect from and where you can, if you have to garnish wages or garnish bank accounts, you need to know where those things are. And the best time to do that is up front when you're interviewing the applicant to lease your property.
So, like the mom and pop landlord, you mentioned earlier some workout arrangements and things with. What do you recommend they do when the tenant initially falls behind, as far as when they consult with you? Are there sometimes it just makes sense to go forward with the eviction, where other times it doesn't at that point? There's also the attorney's fees costs. Like, how does that, if you get approached by a mom and pop landlord, how do you handle that?
So, Georgia law requires some very specific actions to be taken before you can even file for what's called a dispossessory warrant, where we commonly refer to it as an eviction process. But it starts off with this dispossessory warrant. There are some things that every landlord must do before they can even apply in the court for that dispossessory action to be commenced. My recommendation, whether you're mom and pop or you're some large entity, do those things whether or not you eventually decide to file the eviction. Meaning, when the tenant is late, send them a notice, putting them on notice that they're late, letting them know if they don't pay by the date that they're supposed to pay according to their lease agreement, that eviction or dispossessory actions will commence, and follow through on that. Metro Atlanta, most rents are going to be upwards of $1,000 or more per month. right? It's rare that you even can find $1,000 a month in rent. So the more you delay this process, the bigger the amount becomes, and it becomes at some point greater than what the tenant can cure. So if you allow a tenant to go on for several months without paying and without you having taken the proper actions via court, you may end up with a tenant who would like to stay and would like to pay, but simply cannot overcome the deficit that they've created for themselves. And so I always encourage landlords to put yourself in the position where you can move forward with an eviction if you decided to, but don't delay that process, because if you delay it, then you're further moving back the time for which you can commence this dispossessory process. So be sure that you sending out the notices, you let them know to pay or leave, and if they choose not to, you then file for the eviction. A landlord can always drop the eviction case, right? So if the tenant says, hey, I'm ready to pay, I got a good settlement, or I made, my work bonus check came in and they want to cure it, you can always stop the case. But you have to do certain things before you can start it. So mom and pops, landlords, I say, don't be so friendly with your tenant that you forget that this is still a business transaction. And that business transaction has certain obligations and certain requirements that you need to follow in order to protect your investment.
So I'd imagine a hot topic is the issue of a repair. There's something the tenant is alleging is wrong with the unit, whether it's minor or significant, and the landlord also is potentially wary of the allegation. They might think it's the tenant's behind on rent, and that's and really the tenant's just making this up to avoid paying the rent. So if you could first explain sort of the law in Georgia about the duty to repair and how that comes in when the tenant is either not paying at all or just paying a lesser amount than the lease amount.
All right. So as an initial matter, I want to be clear that under Georgia law, the duty to repair and the duty to pay rent are two separate and distinct obligations, one held by the landlord, the other held by the tenant. And what that means is that a landlord cannot refuse to make repairs that they're required to make simply because a tenant is not paying rent. And vice versa. The tenant cannot refuse to make payments of rent simply because the landlord does not make repairs. So let me take the first part. If a tenant is not paying and there's a repair issue, and that repair is a part of the duty to repair that is found under Georgia law, the landlord must still make those repairs. They must go out and use competent workers or themselves and to fix the issue in a good workmanlike manner. And so they can then, if they find that, hey, the tenant is responsible because they did this, like they neglected to let the water run when there was ice, and we sent them notice to do so, and they neglected to do so, causing the pipes to burst. The landlord would need to fix it, but you could then say that it was the tenant's negligence that caused it, and then seek reimbursement back from the tenant. So landlords should never at any time not repair something, whether or not the tenant is paying, because you will not be victorious under those circumstances. And on the other hand, tenants, when you feel like, hey, I've made requests to my landlord to have certain things repaired, and my landlord is a slumlord, they don't fix anything, And it has a couple of options there. They could use the rent payment to make those repairs and provide the landlord with the receipt that shows that rent was used to make the repairs that are the responsibility of the landlord to have made. And then the landlord will, if all of that is true, the landlord cannot then come after the tenant for those rent amounts that the tenant applied to the repair of certain issues in the home. Now, tenants should be careful, though, because I have seen where, for instance, let's just say a toilet, is stopped up and it won't flush. And the tenant says, "Oh, well, I went out and I got a contract and he charged me $600 to unstop the toilet," and then seek to deduct that from the rent amount. Well, that's not reasonable. And so these amounts that are being deducted must be reasonable for the repair issue that they're facing. And I always recommend that communication is key. What that means is that if a tenant anticipates deducting rent money for repairs, that I would recommend that the tenant send the landlord notice. "Mr. Landlord, on such and such date, I advised you that this was an issue. As of today's date, that issue's still not been resolved. My intention is to take next month's rent, and I will be using contractor ABC, who will perform XYZ work, and the amount that they're charging is X amount of dollars. I will deduct X amount of dollars to pay that contractor, and I will tender you the balance of the rent by or on the day that the rent is due." Right? So you are protecting yourself, you're giving notice, you're allowing the landlord to know exactly what's going to come out. And then the landlord sometimes might take that and say, "Hey, no, my contractor can do it for cheaper. Let me get my contractor out there immediately," and he might get the issue resolved. But if they don't, at least the tenant has provided themselves with some level of coverage should this matter be litigated in court. And I say the same for landlords. When you get a repair request, document that you received it, document what actions you've taken to correct it, document what you have learned to be the cause of those issues. If sometimes you have plumbing issues where children may have stuffed toys into the commode and cause the backup, well, that's negligence. And so while the landlord be responsible for that initial cost, they can then note that they would seek reimbursement back from the tenant. So I would communicate that to the tenant. "Hey, you reported this on day X. We sent out our repair person on day Y. The repair person's analysis suggests that the issue was caused by Z, and that is an issue that was your responsibility and your negligence caused that. The cost for this was X amount of dollars, and so we are seeking reimbursement for that." So I think that those kind of communications are very helpful, and they're not done as frequently as they should be.
Okay, so let's now take the scenario where, unfortunately, we've got to go through with the dispossessory proceeding. You mentioned earlier a little bit about this, that the landlord has to do certain things beforehand. Can you just talk us through from soup to nuts exactly how long it would take a landlord to go from the start of the dispossessory process all the way to obtaining the writ and actually removing the tenant from the property? And, just how long that would take and what are some of the potential costs?
So you and your listeners might be disappointed in this answer. It's not a lawyer answer, it's just a reality answer, is that it depends. It depends on where you are, what county you are handling the dispossessory in. Dispossessory actions take place in the court of the county in which the property is located. So there are some counties who are very proficient, and those dispossessory processes can come and go very quickly. From the initiation of a dispossessory action, a tenant has 7 days after being served to respond with their answer to the landlord's request to have them evicted. If they fail to respond, then the landlord can request a default judgment where the tenant can be evicted without having been heard in court. If they do respond, then that court will set up a hearing, and at that hearing is where the judge hears from both sides and makes a determination based on the evidence as to whether or not a money judgment should be rendered against one or the other party, and also if the tenant is found to be in breach of their lease agreement or of their obligations, the court can then give them 7 days to vacate the property, and that is the maximum amount of time that a court can give in Georgia. The court cannot, on its own, provide a tenant with any more than 7 days to vacate. By consent, the landlord and tenant can agree to however many days that they want, but a court, in issuing its order, can only give the tenant 7 days. Once those 7 days are given, if the tenant is not out, then that's when you have the writ process that will initiate. The landlord is then required to inform the court that the tenant did not vacate timely, and then the sheriff or marshal, or depending on the county that you're in, will be called upon to go to the property, and this is the legal actual eviction, is when the sheriff or marshal shows up, removes the tenant's belongings from the property, and places them on the side of the road. Now, different counties have different rules, meaning that the landlord is required to supply the labor that actually picks up the items and puts it outside. Most counties require that, the labor force, I believe most of them require at least one person per bedroom. So that, to give you an idea as to how many people the landlord need to make available to move those things out of the house. And the marshal or the sheriff at that time is simply overseeing that process. And then that process, getting the marshal or the sheriff out to the property, it just depends on their schedule, how they set it up, whether or not the landlord is using a commercial service to do the eviction, or if it's just, them doing it on their own, meaning that instead of hiring a company like, there's many companies out there that supply eviction services, but some landlords can just get, 5 family members, I guess, to move things out. So the sheriff or the marshal's office will determine how they order when you get an eviction completed. I have seen some areas where the eviction is within a day or two of making the request to the marshal or the sheriff's office. I've seen others where it can take 4 to 6 months before they're actually able to go and, move them, evict them out of the property. One thing is certain, though, is that landlords should take note of that regardless of the fact that you won in court, you are not allowed to take any self-help measures to evict the tenant. You can't cut off the electricity. You can't change the locks. You can't do anything until that sheriff or that marshal shows up and removes them from the property. That is the eviction. And to tenants, I caution them that, you may want to, after you lose in court, you may want to get out, as the court informed you about the time you had to vacate, because you never know when that sheriff or marshal may show up, maybe in the most inconvenient time. It could be 6, 7, 8 o'clock in the morning. They'll knock on your door. If you don't answer, they will unlock the door, come in, guns drawn, and move anyone in that house out of that house. regardless if you're entertaining family members, if you got, kids that you're nursing or something like that, you're in the shower, you're coming out of that house at that time. It's not it's not an exciting or event to watch. Sometimes that's why they use the sheriff or the marshals, because it can be a very dangerous situation. You don't know if tenants have guns in the property, dogs, or things like that. So the owners or landlords are not allowed to do that process on their own.
So I think about the last thing I want to cover in Landlord Tenant is the issue of the security deposit. I know you could have the one extreme of the tenant who didn't pay for whatever, 5 or 6 months. And then on the other extreme, you had the perfect tenant who made all the payments and the property's pristine. And then in that scenario, the landlord has really no reason and the landlord won't return the security deposit. So what is the law on security deposits, and what can the tenant do? What can the landlord do when there's been a default on the other end?
So let me just say this, that the issue of security deposits in Georgia is codified in the statute. And depending on who the landlord is and depending on who the tenant is, the rules apply differently. Meaning like commercial tenants and landlords have different requirements. Residential have a different requirement than a commercial. Whether or not you use a property manager, whether or not you own more than 10 units. So what I would say to anyone who is facing security deposit issue, to consult an attorney so to make sure you understand your basic rights. Okay, so I'll give you that caveat. But I would say in general, this is what should be happening. In general, you have at the time that a tenant vacates the property, whether they vacate by eviction or whether they vacate voluntarily because of the termination or expiration of the lease, meaning they've done everything they're supposed to do, now they're just moving out. After the tenant is no longer in the property, the landlord, the owner, should inspect the property. They should inspect the property and see if there are any damages outside of normal wear and tear. If there are any damages, they should note those damages and make the tenant aware of a list of damages that they inspected when they visited the property after the tenant moved out. The time frame to do that, let's say generally is 3 days, but whether or not that applies is another question of when the landlord should be contacting an attorney. But let's just say generally, after a tenant moves out of residential property, the landlord has 3 days to inspect the property. Once they inspect the property, they should produce a list of what they perceive as deductions. And those deductions should be presented to the tenant so the tenant can have some awareness of what it is that they are being charged for. Now, on the other hand, a tenant within 5 days of moving out should be requesting, if they haven't already received, that list of deductions and asking, hey, what are you taking anything out of my security deposit? What is it? If not, I expect my entire amount back. So once that has been done, the landlord then has 30 days to actually tender the balance of the payment. So if tenant has put up, let's say, $2,000 in security deposit funds, the landlord, should be giving them a ledger saying, hey, here are your deductions. You owe me for a month's rent. You busted out the water heater. You left a hole in the wall. Here are those deductions, and here will be your balance. And then the landlord has 30 days to tender that balance to the last known address of the tenant. Which brings me to why the tenant, upon moving out and having an expectation that you will receive some security funds back, that you should make sure that the landlord has a forwarding address for you. so that way they can get you your final ledger and your refund back if you're due anything back. There's always an attempt that I see when I'm in court on dispossessory actions for the tenant to believe that it is during the initial eviction process that they can ask the court for their security deposit or try to apply their security deposit to an amount owed. So that's just not the proper time to do that. Remember that the security deposit doesn't come into question until the tenant actually vacates the property. So that way an assessment can be done to see if there are any damages that stemmed from the tenant's occupancy of the property. So that's that process in general. But again, especially on issues of security deposit, because in some instances, the landlord can be held accountable for up to 3 times the security deposit if they fail to follow certain, protocols that are required under Georgia statute. And a tenant could, potentially, even after having maybe destroyed your property, if you don't follow those protocols as outlined by the Georgia statutes, then you have no right to withhold any money from the tenant. And so the tenant and the landlord should be aware of those protocols, and they should seek legal counsel about their particular issues if they're not familiar with those statutes.
Okay, well, so now let's move on from rentals to residential ownership type issues. I know your firm handles boundary disputes and just issues among neighbors. Can you just tell us exactly, some of the kind of cases that have come up and, how easy they are to resolve and how they usually get resolved?
Sure. So probably the most common issue I have is with people erecting fences that one neighbor claims encroaches upon their property. And others probably deal with trees falling down and damaging someone's property. So in general, boundary disputes are encroachment issues. They're normally quite easy to resolve, but at the time that the neighbors are dealing with it, what I find is that they have gotten so emotionally invested in the issue because they've been going back and forth with each other for such a long time that they just want to go to court, right? They just feel like, they have, they're being wronged, and they just want to be heard by a judge. But most of these issues, most of them, could be resolved with a simple survey. So a survey is basically a report that identifies the boundary lines for each parcel of land. And a survey can tell one whether or not there is an encroachment onto someone else's land, right? Did you, build your fence so close that maybe the post or part of the fence is sitting on someone else's property? And if that's the case, then the owner of that property has a right to tell you to get off. And it really doesn't matter if it's an inch, a foot, 3 feet, whatever it is. Some people, somehow have the impression that if it's just a nominal encroachment, that it's okay. And in fact, it's not. And that's a real big issue. And I would suggest to all landowners to know where your boundaries are and to be aware of them and to, speak out against anyone who's encroaching on your property, because in Georgia, there is this opportunity for one who uses your property in a particular shape, form, or fashion as prescribed by law to adversely possess your property, meaning that if they've been using it, you haven't disputed it, and that they can then become the rightful owner of that property. under certain periods of continued use. And so it is very important that owners of land, especially people who have really large land masses, to really know where the endpoints of your land is, because sometimes just looking out into a big field, it could be difficult to know where your property boundaries are, and someone could start using your property in a continuous way where they just, adversely possess it. They've been the one using it, taking care of it, and you haven't, and then they could just, become the new owners of your property. So make sure if you purchase a home that you actually get a survey. I recommend a survey prior to purchasing, so that way, there's certain times there's like fences and certain things that are up that people just assume create the boundary lines. Well, that may not always be the case, right? So sometimes people, set their fence back way further from the boundary line because, they may have wanted to use that other space for something else. So you really want to just know where your boundaries are and then prevent others from encroaching on those boundaries. What I find as to how these cases are normally resolved, it's based on what the professionals say. So what does the surveyor say? Does the surveyor say that there is an encroachment? And when the answer to that question is yes, then as a matter of law, the court will rule in favor of the homeowner whose land is being encroached upon. I also find that the courts normally will award attorney's fees to the prevailing party, and sometimes when the encroachment is so egregious, the court could award damages, and the court gets to decide, the amount of those damages. So let's just say, Peter, that I encroached on your property intentionally, and you came out and you said, "No, Randy, this is my land. You have your, you're building a pool on my property," and I'm like, "And what you gonna do about it?" Right? I need more space because I can't get the pool that I want. Do you want to sell it to me? You say no, and I say, "Well, I'm building it anyway." And so and that kind of egregious, just hostile takeover of somebody's property, it wouldn't be surprising for a court to award a large amount in damages, even if the amount of space that I took from you was small. And so sometimes people confuse and say, "Well, it's just, it's only 2 inches, it's only 3 inches." But for Georgia, the courts are allowed to award damages even if the encroachment is nominal. So that's something that, everyone should take into consideration. And the cost to fight these kind of cases, because these kind of cases, they are to the exclusive jurisdiction of the superior court. So you can't go to magistrate court and fight about a boundary dispute or state court. It is done in the superior court, who decides, property boundary disputes. And as such, it can be very expensive. If you have, like some people place their homes under an entity, like an LLC, and they do it for liability purposes. And once you've done that, the reality is that now you must hire an attorney, because that LLC you cannot appear in court unless you are in the superior court, unless you are a licensed attorney on behalf of someone else. So if you have, deeded your property over to an LLC for liability purposes, and you encounter one of these type of encroachment issues, then you are required to hire an attorney to represent you. While there's no standard fee that we can talk about for attorneys, you can expect to spend several thousands of dollars for an attorney to represent you in superior court.
And I know you mentioned in the process of purchasing a house, you recommend getting a survey done. Well, let's just talk about other things that can come up in the purchase of a house. And I'm thinking of the disclosures that the seller puts forward, And then, of course, someone buys the house, they get in the house, and then they say, hold on a second, I didn't know that was wrong with it, and it's not in your disclosure. Who knows? I mean, I'm assuming an inspection was done by the buyer, but setting that aside, how do those kind of cases typically work?
Yeah, so this is always a good topic because some people try to sell homes, and you have some real estate agents who will market homes, and they say that this property is sold as is, right? And by doing so, I take it that it's their understanding that then the seller has no obligation to disclose certain known defects about the property, and that it reverts to what they call, a buyer beware. So the buyer has all of the obligations to find out anything about the house. Under Georgia law, that's not true. So under Georgia law, there is a duty on the seller to disclose all of its known defects. So if I know something is wrong with the house, the plumbing, I can't just say, oh, I told you to get an inspection. No, you have a duty to disclose those things. And as part of the standard real estate transactional forms that are used by most real estate professionals in Georgia, whether they be the Georgia Association of Realtor forms or some forms provided by the local multiple listing service, those forms tend to have a document called the seller's property disclosure statement. Now, while that particular form is not required to be used to sell a property or to make the disclosures required under law, those forms are helpful in assisting a seller with meeting its obligations under the law to disclose known things that they know about the property. And seller and buyers are, reasonably allowed to rely on those disclosures for certain things that, if the seller says to me that my home is on public sewer, and then I later found out that it's on a septic tank, then the seller can be liable for that. The seller can be liable in fraud or liable in being required to make the alterations, if possible. Something like septics it's not always available to be placed on public water and sewer. And so they could be held liable up to, potentially rescinding the whole contract and having to give the buyer all of its money back. I've had a case where, for instance, there was a fire at a house, right? And there were significant repairs and renovations done because of the fire. The seller did not disclose that. And the buyer found out that there were certain joists and things like that were fire damaged. And that was fraud, right? And the seller ended up paying my client a substantially large amount of money because of their failure to disclose these defects that they knew existed in this property. And the question might have been on the disclosure form, like, has any part of the home been renovated or needed a permit to be altered or modified? And the seller would have checked no. That's a lie, right? And there could be severe consequences for that. And so we encourage people to be sure that you're handling the transaction in an open and honest way. Atlanta has a very hot real estate market. You'll be surprised how many people will still buy a property even when you make the right disclosures to them. So there's really no reason to attempt to manipulate or conceal certain things, because when they are found out, they can't come back to haunt you. And And part of the rule is that the time for someone to file is once they learn of the fraud, once they learn of what you tried to hide. We have another case where a previous owner sold a property where there was a pool in the back. And what they did was they took the pool out, buried trees and things into that area, and then covered it back up and didn't disclose that. But then there was some leaking problems, and you find out, oh, you intentionally, did not disclose that you had made these kind of modifications to the property to the point where they were, causing other problems that you knew about and you didn't disclose. So disclosure in real estate sales is very important. I encourage everyone to make those proper disclosures. And I'll give you one other point that is probably really important for people to remember. Let's say you're selling a property and the first buyer has an inspection. They provide you that inspection. They say, here are some things that we want corrected. And the seller decides, no, I'm not going to do those things. Okay. But then the second buyer comes. Well, now the seller has some notice about issues that were uncovered in the first one. And they might need to update their seller's property disclosure statement to make the new purchaser aware of issues that have been uncovered by the first. And so we would challenge them to make sure they're working with a competent real estate agent who will make them aware of those obligations. It's to disclose what you know.
All right. Well, Randy, you are a wealth of knowledge. Unfortunately, we've come to the end of the podcast. I want to thank our guest, Randy Williams of the Williams Law Group, for joining us on this podcast, and to thank you for listening. You can find Randy at THEWLGFIRM.com. WLG as in Williams Law Group. Once again, that was the WLGfirm.com. You can visit me online at brickslaw.com. That's BRICKSLAW.com. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or wherever. All of our contact information can be found in the link below. And for more details, you can personally email me at peter@brickslaw.com.